Let's do it again. I'm sorry.
All right, the court calls case number 12-1-09896. This is Merchants Credit Recourse versus Antoine Holcomb. The matter is before the court. Looks like I've got it set on for a pretrial conference. Your appearance for Merchants Credit Recourse, please. Counsel for Merchant, do I have Antoine Holcomb on the Zoom? Mr. Holcomb, if you're on the Zoom, please say something at this time. If I have counsel for Merchants, please say something on the Zoom at this time. All right, the court will revisit the matter. Looks like there is actually.
She's the interpreter.
Yeah. If the defendant is not present, let me see if I have the counsel present. So, do I have anyone from Merchants Credit Recourse? All right, Mr. Antoine Holcomb, looks like an objection to garnishment regarding this matter. And it looks like he's a person requiring assistance. What is your name, ma'am?
I'm Michelle Blanks, the car provider for Mr. Holcomb.
All right, you have to.
I'm Michelle Blanks, the car provider for Mr. Holcomb.
All right, and have you spoken with him today?
I have not.
All right, so what I'm going to do is I know he's set for 9:30, but I'll wait a little bit longer to see if he's having any difficulty getting here, and then I'll come back to this matter.
Okay.
Thank you, ma'am. The court now calls case number 21-144-120. This is Anderson Medical Supplies Incorporated versus City of Detroit. The matter is set before the court on today's date for review. Your appearance for Anderson, please. For City of Detroit.
Good morning, Your Honor. Heather Powers on behalf of the City of Detroit.
Your P number, if you will, for the record, Madam Counsel.
P84510.
All right, go ahead, Ms. Powers, and update. It looks like I don't have the plaintiff here regarding this matter or their counsel.
So I am not quite sure why they're not here. We had an issue with the notices prior where my office was substituted on the notices for plaintiff's counsel, so he didn't receive them. This last notice did have them on there. I spoke with an attorney from their office, somebody who should be appearing. If Your Honor's all right with it, I'd be happy to reach out to him and see what's going on.
I would appreciate that. Madam Counsel, let me know when you've done so. I'll come back to your matter at that time. Thank you.
Thank you.
All right, the court now calls case number 22-178-326. This is Al Rada Bakery LLC versus Eastbourne Partners LLC and Trinity Construction LLC. The matter is before the court. Looks like I've got this set on regarding objections to a writ of garnishment. Your appearance at this time for Al Rada Bakery LLC. For Eastbourne Partners LLC.
Good morning, Your Honor. Aaron Cox, P69346, appearing on behalf of Eastbourne Partners.
Thank you, counsel. For Trinity Construction LLC. All right, Mr. Cox, hearing no others, update me, sir.
Your Honor, I don't know that I have an update for you. You've indicated that this was for an objection to garnishment. I'm not sure that a final order's been entered on this file. My understanding is that we were here today for a status conference. And the update on that status, Judge, is that there really hasn't been any action taken on this file.
All right. So have you spoken with, so what you're saying to me, and I haven't looked at the register just yet. You're saying that there's not been a judgment in this matter, correct?
Not that I'm aware of, Your Honor, no. Trinity was dismissed on summary disposition a number of months ago. And I'm looking at the ROA now. No, nothing's occurred since.
And I do see that such motion was scheduled and then it looks like rescheduled, motion for summary disposition held, review schedule. The summary disposition motion was granted. Trinity was dismissed from the case. Right. So that seems to be where things are, is that Trinity has been dismissed, but there seems that there's not any other resolutions regarding this matter. Once again, Rada Bakery LLC, anybody from that, council, you want to reach out to them and see if they're coming into this hearing? I'll come back to you. Just give me a signal when you're back in.
So, sounds good, Your Honor. I'll follow up with them now.
All right, thank you, counsel. Madam Counsel, regarding Anderson versus City of Detroit, any update at this point? Ms. Powers, all right, I don't see her indicated. Thank you. All right, the court now calls case number 13-118-708. This is Tidewater Credit Services versus Tawana Ray Smith. The matter is before the court. Looks like on objections to a writ of garnishment, it does appear that the court recently entered, I'll strike that up, your appearance at this time for Tidewater. Do I have Tawana Ray?
I'm here.
All right.
Yes.
So ma'am, tell me, why are you here? Talk to me.
Hi, good morning, Your Honor. I am here because I have been trying to find this on my credit. I can't find it. And
Let me stop you. Let me stop you. I know I didn't get it forward. Let me stop you a second.
Okay.
The court's on this. I see that you filed objections to a writ of garnishment. I have photocopies of that, or micro copies of that. I don't have the actual documents. So this was back in, looks like filed sometime in, it looked like the court may have received this in 10/13/22. You said you don't recall opening up this account and can't dispute a debt or on my own credit report. I can't make out what else you said on here. So you're objecting to a garnishment that is being advanced against you?
they have stopped the garnishment.
Yeah.
Yes, that was start.
Go ahead.
Okay, and I was objecting to having to send Tidewater more money when it's not I didn't open this account.
All right. Did you file a motion to set aside the default judgment now?
To be honest, I'm not sure.
Yeah. The long and short answer of that is that you did. If it is your interest in trying to get the judgment set aside, you have to file a proper motion in that regard. The objection to the writ of garnishment is a post-judgment matter, meaning that a judgment has already been entered, and that you are objecting to the effort to collect from your income or to take your bank account or something like that. But if you wish to attack the underlying judgment, you have to file something to show why you didn't respond to the complaint, and number two, that you have a meritorious defense to the claim that is brought against you. So that's in the nature of what's called a motion to set aside a default judgment. So that's not before me today. If you wish to file that, you could do so on the second floor at the 36th District Court. But
Okay, I live in Georgia. Is there somewhere to do this online?
Yeah, you can do it online as well. All right. So what you want to go to 36th District Court.org, and then there should be some information to direct that towards you now. All right. And let me just look at one other thing here. It looks like this is a debt that Tidewater purchased from another entity, and this has to do with a certain Gardner White purchase allegedly made back in, just to give you some information I see. Wow. October of 2006, it appears. So that's what this seems to relate to, ma'am. And again, that judgment was entered back in 2013. So you're going up almost 10 years ago that the judgment was entered in this case. So that's what it's about. I know oftentimes people hear a particular creditor, they're not familiar with that creditor. That probably means that debt has been sold to a subsequent creditor. But this arises out of something to do with Gardner White. All right, but you have the right to file a motion, as I've indicated to you, and you submit that motion before the court. It will be reviewed, and a decision will be made on your motion as to whether or not there's a basis to set the judgment aside. At the present time, the garnishment is suspended, and you're allowed to pay the $75 a month to prevent the garnishment from occurring in the interim. If your judgment is set aside, then you will be entitled to refund of the money that you paid. All right. I wish you well, ma'am. Good day to you.
Thank you.
And I believe, Madam Counsel, Ms. Powell, regarding Anderson versus City of Detroit, the suffix 4120. I believe you're indicating that you have some information now. You may.
Yes, Your Honor, I talked with plaintiff's counsel. We have settled the matter.
All right. So what I'm going to do is I will note that there is a settlement in that that the court is anticipating an order in that regard. So that makes sense? Now,
Yes, Your Honor.
I have an order. Is this something that's going to require a city council approval?
I do believe anything over 2,500 does require city council approval, and we are
So
above that.
I have an order that I'm going, that if it's okay with you, I'll go ahead and issue it. It's an order allowing for additional dismissal subject to approval of the settlement. And when the settlement is approved, then the order becomes a final order. If for some reason it's not approved, the case is automatically reinstated. That makes sense to you?
I'm fine with that, Your Honor.
All right, the parties will get an order from me in the mail in the next couple of days. All right. All right.
Thank you.
Thank you, counsel. Good day to you. All the best.
You too.
Was this an objection?
Yeah, the objection. I don't know where the original paperwork is. Okay. In the computer should be noted that the objection is denied. Garnishment is suspended. So it's partial payment. And that would be consistent with, this. Will be consistent with this. It's suspended in light of the court's entry. All right, the court now calls case number 19141-832. This is Credit Acceptance Corporation versus Donna McGowan. The matter is before the court on objections to a writ of garnishment. The record should reflect in this matter that a judgment was previously entered by consent in 2019 for $7,623.35. The plaintiff seeks to collect on the judgment by way of the garnishment. I believe there was previously an agreement for partial payments. Your appearance for credit acceptance, please.
Good morning, Your Honor. Alexander Popov appearing on behalf of plaintiff P84378.
Thank you, counsel, and good morning to you, sir. I'm looking now for Ms. Donna McGowan. If you're on the Zoom, please say something at this time, ma'am.
I'm here. I'm Deanna McGowan.
All right. I've been calling you Donna all morning. Thank you.
Yeah, that's
Thank you,
okay.
Ms. McGowan. Thank you, and good morning to you, ma'am. I know that you filed the objection to the writ of garnishment. You said it stated on garnishment disclosure may not be able to pay because of off-season July through September. So you're saying that there was a payment plan, but when you were no longer on the school payroll, that's why there was not payment. Is that correct?
Yes, correct.
All right,
That's correct.
All right. So, counsel, I don't have the agreement that the parties reached in front of me in this regard. So, any updates or insight into as to what may have gone wrong?
Yeah, it looks like we had an installment payment order dated 10. It was issued on 1/12/22.
Right.
and then she stopped paying on that, and then we got, it was set aside, and then we garnished the wages. And now we're at with the wage garnishment.
All right, got it. Well, it looks like, was there ever an agreement that that the defendant, Ms. McGowan, would have off during the summer months? Because I mean, if you don't have that agreement, then you have to structure things where you continue the payments, because the order is the order unless there is an agreement to the contrary. Go ahead, Ms. McGowan.
When I called and talked to someone at the lawyer's office in June, when I had the installment stopped, and the only reason why I had them stopped is because I knew I wouldn't have any money coming in, and I didn't want to end up where I'm at now. When I sent them the thing, I told them that I wouldn't be able to pay it until September. They sent the agreement for $150 to start in August. I did not sign it because I did not have money to send them in August. And I told them that when I talked to them on the phone, like, I can't pay you until September. When I got my first payment in September, it was, they took $263. They said I hadn't paid them at all. I left reports saying that I didn't even stop the garnishment. The garnishment was supposed to stop in March. I never stopped it because I knew I wasn't going to be able to pay it. And I thought that would give me a way to catch up. That's why I called them to start the agreement, because the judge had ordered for me to only pay $100, but I agreed to $150. But because they said, well, we want it in August, I told them, well, I don't have it. So we'll let the judge decide.
Well,
And
yeah, what you did, unfortunately, is you broke the agreement, and without the other side agreeing to, no, you're listening to me now. You
Yes,
broke
I
the
am.
agreement.
I am.
What you did is you wanted them to waive any payments during those months. They sent you out something for you to agree to a payment in August. They were agreeing to waive June and July, but not August, and you didn't sign that. You didn't sign
But I
that.
didn't have any money in
Seems
August.
sounds like you cut me off, no.
I'm sorry.
That's the situation. Here's a rub on it. You put yourself in that situation. I mean, everything has to be by a written agreement. If you call in and say that I can't pay, and they say, well, okay, we understand you can't pay, and you say, well, I want to adjust it. They say, well, maybe we'll adjust until you get something in writing that it hasn't modified the agreement. Okay, we have that funny look on your face. So tell me, what do you have in writing between you and the other side that says that you don't have to pay during June, July, and August?
It's on the court papers. Hold on.
Okay, point me to
Wait,
that.
wait, I'm pulling them up now. Hold on. I'm sorry.
Okay. All right, and counsel, do you have anything to that effect?
Your Honor, the only thing that I have is the judgment, which states that should pay on X date, but there's nothing about on these months she's not going to pay.
It said it in the right to the garnish. Oh God, I don't have it in front of me. But it says it on the second page on the right to garnishment. It says that the judge wrote it in that she may not have enough money to pay. It's written in on the right of garnishment.
Well, even if the judge wrote in something on the garnishment that she may not be able to pay you, if the order is for payment, then the order is for payment. So I'm going to take a moment here and look at orders just to see the genesis of the agreement, because it looked like the parties reached a consent here. And I think that there is a path forward, but the bottom line is that if I don't have a document ordering you to make payments and allowing you to stop payments at a certain time, then the only way that could have occurred is if the parties entered into an agreement to do that, and then put that reduce that to a right. That's the rub here, is that I don't see anywhere where the parties reduced that to a writing and both sides signed off on it. Now, let me just looking. All right, I have nothing, I have nothing in my file, which, if it's a court order, something signed by, the judge, granting that type of relief, it will be contained in the court's file. I don't see anything on registered action, nor, do I see, any court order, in the file that does it, nor do I see a stipulation by the parties. I guess what we come down to is that you can't, there is no way that you can modify the order except there is some agreement in writing to do so. So that's why the garnishment issue, because you shouldn't be garnished if you stay on the payment, but that's why the garnishment issue. So what do you want to do? What do you want to do at this point? Obviously, you demonstrated that you have ability to pay and that you are consistent with making payments, but you got to fix this situation, because I don't think that there is something here where they're agreeing that when you get to those months off, that you can stop making the payments. If you don't have that agreement, then you're not going to be able to do that, and that's going to put you back in this situation unless the other side is willing to agree to that. That's what I'm saying. So we can get you off the garnishment, I'm sure, today, but this could become a reoccurring problem every year, and then by the time you start back up, you're going to be sitting on the garnishment. The garnishment is going to be, of course, 25%, whatever your take home pay is. So what do you? I don't see a basis for granting the objections, but I do see a way forward because I know you want to get off under the garnishment. Before I come to that, Mr. Counsel, anything further from the defense position?
Your Honor, in regards to the garnishment itself, nothing further. I mean, there's been no agreement on like certain months, and we request that the objection be denied.
All right. So, how much money's been taken from you since you got back into the classroom, then, or back at work?
I would have to say maybe close to $1,000.
Yeah, that's right, Your Honor. A little less than $1,000.
All right. All right. So I will go ahead. And I'll find that there's no valid objection to the garnishment. However, and I will release the withheld funds to the plaintiff. I will stop the garnishment. How much you want to pay on this on a monthly basis?
I could pay $150.
All right, so I'll go ahead and set it up at $150. When is your next payday?
The 15th of November.
Okay, so you should be able to get this into your payroll before the next payday.
Yes.
So, and then that will stop the garnishment. Let's begin your payment under the order. You said, okay, yeah. So you get paid on Tuesday, the 29th?
Yes.
11/29/22. We'll get you back on the partial payment at $150 a month, and the garnishment is suspended in light of that dynamic. All right. So I'm signing orders consistent therewith, and both parties will receive copies of the orders momentarily. I do wish you well. It's a crazy situation, but this is how those things happen. And I know that when the summer comes, you got to figure something out because of the way that this works. Okay, if they're not agreeing to you got to figure something out so you don't end up with a garnishment type situation. All right, all the best to you.
Thank you so much.
And thank you, counsel.
Thank you, Your Honor.
Your Honor, Mr. Hooper will not be appearing today.
Did you come to, or you could?
Well, if I recall, last time we appeared in court, you ordered that merchants credit reports return his money back to him.
I'll take a look at that. Yeah, I do remember something along those lines. Let me take a look. So, this one. So do I have counsel on Mr. Cox? Are you back on this matter, sir?
Your Honor, if I could just have one more second, I'm going to try to make another phone call to plaintiff's counsel.
Not a problem, sir.
Thank you, Judge.
All right, do I have counsel on merchant credit recourse? Merchant credit recourse? All right, the record should reflect regarding the suffix 9896 on the previous date, the looks like the in October, there was a stipulation order for conditional dismissal without prejudice. And so this case is dismissed. And that was the stipulation that was reached regarding this matter. So that case is dismissed, right?
Yeah, this was just a reserved court date, just in case Mr. Holcomb's funds would not be returned to him. He reserved this case.
Got it. Got it. State your name for the record, just so that my court reporter has you down.
So I'm Michelle Blanks, Blanks, the park provider for Mr. Holcomb.
All right. Thank you for being here, ma'am, and thank you for bringing this to my remembrance as well. So this case is closed out in that regard. Thank you. All right, ladies and gentlemen, thank you for your patience. We are working through these matters. Fell a little bit behind today. This is case number 21-162-488. This is Vibe Credit Union versus Eric Cox. The matter is before the court. Looks like it's set on regarding objections to a writ of garnishment. Your appearance for the plaintiff regarding this matter.
Good morning, Your Honor. My name is John Butler, P33908, on behalf of the plaintiff.
All right, and good morning to you, counsel. Do I have Erica Cox with me today?
I am here.
All right, good morning to you, Ms. Cox.
Good morning.
I received your objections to the writ of garnishment regarding this matter. I looked at it, and your objections indicate that I object to the writ of garnishment and request a hearing cause of change of wages. That issue would not have any real application to the garnishment itself. So I don't see where that has much to go. But I do see that you also filed an application for installment payments. And what you've indicated to the court is that you'd like to be able to pay this by way of partial payments at $50 a month. Is that correct, ma'am?
Correct. Initially, when I had applied for the loan from Vibe, I was living at home with my father after my mother's passing. Since then, there was with no bills, no responsibilities, just trying to get back on my feet after my mother's passing. With that, there was a rift between my father and I. So I went, I had to move, which caused, having to all of my income. Well, I was also working 2 jobs as well. So I'm currently employed with 1 job, providing for a family of 4, solo. So that's like, and I had reached out when the initial paperwork in regards to the garnishment or the original court case that came out. I had reached out to the lawyer's office via a letter in writing that was returned to me. And then I had also tried to call, but the number listed on the
Let me
paper.
stop you for a moment. Let me stop you. I appreciate that, but I don't care about that.
Okay. Well, yes, I'm requesting that because
I got a couple other here. Let me get at it this way. Has any money been taken under the garnishment? Has your check been intercepted at all?
yes, my check from last week, I was garnished $490, I believe, or $489 or something like that.
Yeah, that's close enough to 490. You get paid twice a month?
Correct.
So that garnishment would put you at like $1,000 a month that you take it if you don't get some alternatives. Is that
Correct. And that's like almost
So
half
let me
of what
stop.
I'm
I know you can't afford to do that, right?
at all.
How did I know you were getting ready to tell me that? All right, let me hear from council regarding this matter. Council.
Yeah, good morning, Your Honor. I think you've spoken to the objection to garnishment. I don't think there's a reasonable basis to object, so I'd ask that be denied. Your Honor, I believe we filed a response. The judgment was 4617 taken last March. It's about 5,100. We have not received anything from the garnishment. We requested 275 a month. I think that would be a reasonable pay, especially if she's almost 500 bucks taken out of the garnishment twice a month. So we would ask the court to entertain an installment payment of, let's say, 275 a month, which would just be a little bit more than, frankly, a quarter of what would be taken now.
Yeah, the $50 is a non-starter. They're asking for a 275. That may be. I understand you told me that you're taking care of a household of 4 and that you don't have the support that you had before. I have to take that into consideration, but I also have to take this consideration that and the amount that you would be hit for if you were being garnished. So any amount an alternative that you wish to indicate to the court. You're at 50, they're at 275. I'll come up with some number, but what do you think?
Maybe 125, 140, something like that. Again, I have 3 big boys. Like, again, I'm not getting any assistance. I'm literally drowning with my responsibilities that I already have. I am, saying that I am responsible when taking this on. The circumstances were very different when I applied for this. So I do want to get the matter taken
You're
care
talking
of.
about that part. Oh, got it. All right. I think the 150 is the one. The $50 is extremely low. The 275, I do think it would pose a bit of a hardship. You do have an indebtedness that's in the nature of $4,600, and you already have they garnished the payment, but they haven't gotten it yet. So that'll take almost $500 off of whatever amount you owe. I'm gonna set that payment at 175.
Okay.
I'll allow payment to commence on this matter on the 25th of November. So 175 a month. I'll suspend the garnishment in light of the order for the payments. I'll release any funds withheld on the garnishment to the plaintiff, and then the garnishment will be suspended in light of the $175 payment. That payment commences on the 25th of November, and you'll receive orders consistent with both items.
Your Honor, briefly, may we do an affidavit of default in the event the payments are not timely made, so it would be set aside without filing a motion?
Yeah, you can do it by way of affidavit. The idea here is that you want to keep up with the payments so that you don't get back to the garnishment. Right, that's going to be real important. Keep up with the payments so you don't get back to the garnishment. Because the payment, I know it's a little higher than you want. It's $100 less than what they want. I think it's a reasonable amount, although I know these are difficult times. But what you don't want is you don't want that $1,000 a month. So you want to make sure you keep up with it. All right, you get orders from me in the next couple of days.
Thank you, Your Honor.
Well, I wish both sides well.
Thank you.
Hello.
There?
Yeah, my computer just crashed. I had to hop back in on my phone. I'm so sorry.
It certainly happens. That's what we're all experiencing in this scenario. You'll get orders from me, ma'am. The point I was making is stay on the partial payment plan so that you don't get back to the garnishment, because that garnishment will hit you for $1,000 a month. So,
Right. So I do have a question though. So because we get paid again on next Thursday, and then payroll goes in on Tuesday, but you're saying I'm still going to be responsible for a payment on the 25th of this month. Is there any way to move that first payment to December? Because I don't know if I'll be able to get the paperwork in payroll to have it processed before the garnishment taken next week.
all right. So here's what I want you to do. Why don't you chat me your email address? I'm gonna have my clerk to email your paperwork to you today, and then you go into what you have to do, okay?
Okay.
Make sense to you?
Yes, sir.
All right, I wish you well, man. Good day to you.
Thank you.
And you saying this one was dismissed with the interpreter?
Yes.
Oh, no, no.
Mr. Cox, you're up with regard to the suffix 8326, and that is on Al Rada Bakery versus Eastbourne Partners LLC.
Yes, Your Honor.
Mr. Cox, I believe it's your matter, Mr. Cox.
Yes, good morning, Your Honor. Aaron Cox, P69346, appearing on behalf of Eastbourne Partners. Mr. Zahair is present on behalf of the plaintiff.
All right, for plaintiff, your appearance at this time, sir.
Your Honor, Mohammed Zahir, P number 5/2020, appearing for the plaintiff.
All right, thank you. Good morning to you, sir. I had somebody reach out to you. I know it was not like you to not be here. So what's going on here?
Judge, I think we need more time in this. I think we're gonna resolve it globally. We have another case in the Wayne County Circuit Court. Mr. Cox and I had some conversation about 2 months ago regarding the whole situation. So I think we're gonna resolve it at the end of the day. So if we need like more time in this. So I don't.
I think you told me, I think I heard you say that you guys had a conversation 60 days ago. I'll give you some more time, but I don't want you to have a conversation every 60 days. What do you think, Mr. Cox?
Yeah, Judge, I mean, we are still discussing and working, but I think maybe the appropriate step is to give us a motion date, sometime a couple of months out. So that in the event that we don't get a resolution, we at least are still on track to try to get a court decision on this issue.
All right, yeah, that course makes sense to me. I'd like to see if we can move this with some traction this year. So I'm going to go ahead and set you up in December, and I'm going to give you December the 22nd. And I'm going to set that as a motion hearing date, and you will be allowed to, you can file your motion and set it for hearing on that date. The only requirement is that you give the other party at least 10 days to respond to your motion. So that gives you negotiating room all the way up, you don't have to have the typical 28 days or whatever. So, if you find out that it's getting there 10 days before the hearing date, then file your motion. The other side has 10 days to respond, and I'll hear it on that date, the 22nd of December. That's going to be at 10 o'clock a.m. December 22nd, 10 o'clock a.m. Will be the hearing date on this matter.
Thank you, Your Honor.
Yep, thank you, Judge.
Thank you, gentlemen. Good day too. Wish you well.
You as
Thank
well.
you.
Court finds good cause for the adjournment of this matter, and the court is setting the matter over for motion hearings and for a retrial conference. So, this is case number 21-170303. This is HS Financial Group LLC versus Jerona Cooper, I believe is the last name here. The matter is before the court on the filing of objection to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case. Looks like the entry date is the 10th of June, 2022. The judgment amount is $1,755.94. Actually, the judgment $1,741.63. And there is a notice of lien was filed previously, and then the issuance of a garnishment and objections that are before the court today. Your appearance for the plaintiff at this time, please.
Judge, may I please court? I am attorney Richard Gruson. My bar number is 35222. I am the attorney of record. And today I am also the respondent to defense objection to a wage garnishment.
All right, thank you. Thank you, Mr. Rosen, and good morning to you. Thank you for your patience. Do I have Giovanna, I believe is Cooper. If you're on the Zoom, please say something at this time.
Yes, I'm here.
All right, what is your name, ma'am?
My name is Giovanna Cooper.
All right, thank you, Ms. Cooper, and good morning to you as well. I do note your objections to the wage garnishment regarding the rededicated physicians group. You indicated your objection that I never received any paperwork. I do not stay at address or file over a year, or on file over a year. So what you're saying is that this is the first time that you're hearing anything about this case?
Literally, the first time I heard about this case is when they sent me an email from my job saying that a writ was processing for a garnishment, and I had never heard about this until they was already taking money out of my account.
All right, ma'am. So I have what occurred here is that when they weren't able to reach you directly, service was allowed by alternative means, and they were allowed to tack and post the item at the address on Montrose Street, and the court allowed that to be added to service in this matter. So that's why the judgment was entered. Now, if you believe for some reason that the judgment should not have been entered, you have to file a different type of motion to try and set that judgment aside.
Yeah, I would like to do that.
Yeah, you have the right to do that. You can file that on the second floor at 36th District Court. The motion that you filed today, or the petition you filed today, is a post-judgment matter. So the only issues that I can address by law is post-judgment matters. Anything that happened before the judgment was entered, you have to bring a proper motion for the court to address that. So today, the only issue I'm dealing with is whether or not the plaintiff could have properly issued a writ of garnishment based upon the entry of the judgment. And under the law, they would have the right to enter that, to bring a garnishment because they have a judgment that was entered by the court back in June of this year. So that's why the judgment is entered. So how much money has been taken from you under the garnishment, ma'am?
It took $306 out of my check already.
$306, ma'am?
Yes.
I can hardly hear you. I was trying to get the amount. What did you say, $306?
Yes.
Okay, and so do you get paid every week or every other week?
Bi-weekly.
Okay, so it sounds like you would be heading for a garnishment at $612 a month. All right, you have not filed a petition for partial payments with the court, ma'am. Would you be interested in making partial payments while you pursue trying to get the judgment set aside, ma'am?
Yes, that would be very helpful.
All right, let me hear from Mr. Rosen, and then I'll come back to you, ma'am. Mr. Rosen?
Couple of things, Judge. I have the copy of the summons and complaint in my hand that was attached, well, that was served if and when defendant chooses to pursue her legal rights in this matter. She's going to have to eventually look at the lease that I have attached to the complaint for apparently leased furniture from Bargain Furniture LLC on East 8 Mile Road in Detroit. That was purported to be signed on August 2017. There were events that were attached to the complaint. Looks like a defendant at that time tried to pay by check and the checks bounced. So she's going to have to resolve that if she chooses to file a motion to set aside default judgment by means of showing a meritorious defense to the plaintiff's claim, which is also a component of the court rule MCR 2.603 to set aside default judgment. But on the other hand, if defendant is willing to make an installment payment today, I'd be certainly willing to entertain that, but I would need to know what the amount of the proposed installment order would be every month.
All right, got it. So yeah, ma'am, so what are you proposing? You've indicated that they've taken $300 already, so Mr. Rusin, has your office received that yet at all?
No, no, Judge, I have not received, I have not even received a disclosure in writing from the Garci defendant, so I'm going to have to take defendants at her word, because I have nothing in hand, both from the disclosure nor any received from the Garci defendant.
Well, I
So,
can
yeah,
email you my check stub that says that they took $306 out of my account. So that's already been taken out. And they're going to take another payment on Thursday. So I'm not making that up about them taking my money.
I'm taking you at face.
I'm sorry, Mr. Rusin.
I'm taking defendant's argument as face value. I didn't mean to like challenge her credibility.
Yeah, what happens, Ms. Cooper, is that there is a process that takes place that's way beyond you getting a check in your hand and saying that they're taking your money. There are a couple of other steps that happen before the other side has any awareness that it has occurred, and that's what that discussion was about. Now, you don't have any
Yeah, this is
control over it.
completely new to me. I've never been in this situation, so this is all new to me. So
Makes sense to me, but I guess the reason I pointed that out, and you pointed out, of course, that another payment will come out. I mean, the judgment in this matter is only, and I shouldn't say only, but it's $1,700 or so dollars, and if you approximately $1,800, if they take out that 600, and that brings you down somewhere near about $1,200, and so I mean, you've taken a big bite out of it, is what I'm saying. So what do you propose as a monthly payment, then, to try and get this resolved? You probably.
I would not have a problem at all paying like $150, $175 a month. I have no problem paying that. I just don't want them to take 25%. 25, like the young lady said earlier, I have the same situation. It's me by myself taking care of me and my kids. So
Yeah, I mean, you raise a good issue. I mean, that's why we're taking time to talk about that, even though you didn't file a motion for the partial payment. I think that makes sense. And at $150 a month, Mr. Rosen, what do you think?
Judge, I will stipulate to that, and I'm looking at my calendar. Today, we're obviously on the record for November 2nd. I will stipulate to an order for installment payments of $150 per month in this matter, that in perhaps 30 days from now, which I notice on my calendar is Friday, December 2nd of 2022. And as long as defendant can pay $150 a month to my office every month, then there will be, of course, no wage garnishment moving forward on the matter.
absolutely perfect.
Yeah, that makes sense to me. Thank you, Mr. Rosen. Thank you, Ms. Cooper. I think that's a very, very reasonable way of going forward with this. So I will grant an order that will allow for the partial payments. The objections to the writ of garnishment, the objection is invalid. Funds withheld will be released to the plaintiff, but then the garnishment will be stopped or suspended in light of the partial payment order that is being entered by the court. And Ms. Cooper, you'll get copies of all of that from me in the next couple of days. Of course, you won't be able to stop that next garnishment, so we're taking that into account. But then your first payment under the partial payment order would be December the 2nd, 2022, and the garnishment stops after this payment that you're going to get garnished for this last one. Understand?
Okay, I have a question. So how do I just call Mr. Bowson office and then I pay them like that, or how do I pay them?
I can answer that very quickly.
Yeah, for a breakout room, Mr. Rosen, or no?
Yeah, I think that would be prudent, Judge. That would be very good.
All right, so I'm going to put you in a breakout room just so you know logistics like that, ma'am. And you'll get a notification from me to go to breakout room number 1, and then you can go through the logistics so you know exactly what you.
Okay, thank you so much.
So there is your notification, and Mr. Rosen will speak with you. There are 2 orders at the end. All right, this is case number 05114965. This is Asset Acceptance LLC. Well, strike that. We already dealt with this one. This is.
I'm here on that case, Judge. Good morning.
Oh, yeah. The name was familiar, sounded like something I called already. This is Asset Acceptance versus Javante Collins. The matter is before the court regarding objections to a writ of garnishment. The record should reflect that in this matter, a judgment was entered by default. Looks like that judgment was entered on the 7th of January, sorry, the 7th of July, 2005. That judgment was renewed subsequent to that time. And looks like the judgment upon entry was $3,597.09. Of course, that judgment is old. There are several garnishments that have been filed in this matter. Presently, the objection is to a writ of garnishment. Looks like this may be computer share payroll type garnishment. Your appearance for the plaintiff asset acceptance, please.
Good morning, Judge. Andrew Perry, P69402 on behalf of plaintiff.
Thank you, Mr. Perry, and good morning to you, sir. Thank you for your patience. Do I have Mr. Collins, Javante Collins on this Zoom? If you are, say something at this time, sir.
Yes, I'm here, sir.
Good morning to you, and thank you for your patience in this regard, sir. I do see that your objection to the writ of garnishment says I was not notified of this request. Are you saying that you thought that you should have got some notice before the garnishment hit, or is that what you're saying?
No, I was not notified of a court appearance or anything like that. I have no objection to the my true objection is the amount.
Yeah, and I guess what I'm getting at is as it relates to the garnishment. The garnishment is what it is. It would be 25% of your take-home pay, and there's not a requirement to notify you prior to that garnishment taking place. If there's a judgment in place, then that garnishment is issued without notice. But I do see also that you filed for partial payments, so you're asking the court would stop the garnishment and allow you to pay this under a partial payment order. You asked specifically. Look like you're saying 200 every 2 weeks or $400 a month. Is that what you're saying?
Correct. Sorry, my handwriting is terrible.
No, it was pretty good to me. At least I'm comparing it to mine, so you did quite well. Let me ask you, when you were garnished, how much in dollar amount, how much were you garnished?
Per one check, it was about $750. This check was $650. I'm at a total of $1,300.09.
Okay, so you get that garnishment will put you basically at about $1,400 or so a month, correct?
Correct.
And you've asked me for the $200 a month payment, and you pointed out the living expenses, rent, utilities, and things along those lines.
Yeah, car notes, kids, schooling, lunch, things like that. Just a daily living. Yes.
Yes, sir.
I guess I'm still trying to. I'm sorry.
How many children do you have?
I have 2 children and a wife.
Okay, yeah. Well, the wife's gonna take all your money anyway, but how much? You might get a break from the children a little bit. How old are your children?
Well, I got at least 18 more years before I get that break.
Yeah, that's what I'm getting at. That's why I asked, how old are your children?
I got an 8-year-old and 9-year-old.
Oh man, we sound like we're in the same family. My last 2 are 8 and 11. Yeah.
You said your last 2? You have a total of how many children?
A total of 6.
I think you can be.
4 are grown. 4 are grown. I did the wise thing and started all over again, but now I'm questioning myself. But anyway, let's see if we can find out something that may work here. Mr. Perry?
Judge, I generally don't oppose requests for payments, but this case is a little different. The judgment's more than 17 years old. Mr. Collins had 2 prior payment orders, and since the entry of the judgment has made no voluntary payments. So both payment orders, one in 2015 and one, I think it was 2019, that entered, allowing Mr. Collins to make payments. He hasn't made any payments on either of the payment orders and no voluntary payments since the entry of the judgment in 2005.
I don't recall a payment arrangement for 2019. I do recall a payment arrangement from 2015, which I can't tell you the state of mind I was in 2015. However, I can only tell you what I'm capable of doing now. So now I'm in the process of building my credit correctly. And so that's what I'm in the process of doing. And this right here doesn't help in my efforts because you're taking 25% of my pay, which puts me behind of everything else. So essentially I'm robbing Peter to pay Paul. And I'm trying to meet somewhere in the middle to where I can pay it and consistently pay it.
Yeah, this would catch up with you. I mean, that's a part of the challenge here.
Yeah, as I said before, I'm not debating the actual debt. I'm debating the value because it says a judgment was entered 35, but 6,950 was sent to my job. And so that's where my confusion is.
Yeah, well, that's what happens with interest over 15 years. That's your challenge on that part of it. And of course, the parties sometimes want to get together and see if they can resolve it by lump sum payment. Sometimes the parties can do that and maybe avoid some of the interest, but that's for you all if you want to talk about that. The concern here is whether or not you'll keep the payment. The amount that you offer is substantial. And how long have you been working for Computer Share?
I've been in Computer Share about 8 years.
All right. So here's what I'll do. I'll grant your petition for partial payments in this matter, sir.
Okay.
And I will give counsel the right to set it aside by affidavit before the court. That means that you gotta keep it going. Otherwise, what will happen is that
I'll be back here.
Yeah, the garnishment that's being suspended can be reinstated by affidavit. So it doesn't even have to have a court hearing. If you miss payments, then they can do an affidavit and get the garnishment started back right away.
And
I can only imagine what it's like. I've raising kids all my life, but I can only imagine what it's like trying to take care of a household and having to pay out $1,400 a month on a 15-year-old debt. So, I mean, getting off from under that seems to make sense. So I'll go ahead and set it up. I'll go ahead and set it up in the manner that you have asked. I'll set it at $400 a month. Now, you want to make that one payment, or are you trying to make a 5-monthly payment, or?
I'll more likely make it I'll have it come out automatically out of my bank account. So I'll set something up with his office. I just need to know the information that I need.
All right.
Judge, just to clarify for the record, I pulled it up. The last payment order was dated March 14th of 2018, and that was his second payment order. And again, Judge, he's had 2 payment orders, and there's been no voluntary payments that were made on this judgment. It's all through forced collections.
Yeah, I mean, I think that you made that point the first time around, counsel. I mean,
well, Judge, he said that he didn't have.
He didn't recall it.
I said I didn't recall. And like I said, I'm willing to set up a payment to automatically come out on my payment. I need the information. So if you can provide me the information.
It's appropriate to raise, let me stop everybody. It's appropriate to raise the issue of can we rely upon that payment when there's been one time where there wasn't reliance, and it's even more an issue when there's been 2 times and there was a lack of reliance. So I see counsel raise. I'm just saying I heard it the first time, and I heard what the defendant said. He doesn't recall that. He didn't deny that might have been the case. He just didn't recall it. The issue now is going forward. I'll give him another opportunity to pay it, especially at $400 a month. I think that's a substantial amount to pay, but of course it relieves him from having to kick out $1,400 a month. And of course, the court does have to take into consideration the defendant's circumstances as we consider these things as well. So I'll give him the opportunity to make those payments. And if you want me to, counsel, I'll even set it for a review 60, 90 days down and set another hearing on this to see if the payments are being made, because obviously that's a critical issue here. This is not going away.
Yeah, Judge, actually, I think that's a great idea. If we could set it out maybe 60 or 90 days for a review.
In any event in the 60-day review that all requirements are met, what are our options then?
Yeah, I mean, then what we do is we consider whether or not to review it again in 60 days or 90 days, or whether to not do a review. If there was not two previous situations where there wasn't compliance, then this would not be an issue. And my thought is that it's not an issue going forward. I believe that Mr. Collins is in a different place and he wants to get this behind him just as much as the plaintiff would like to see this close out as well. But we have to test it. I think a reasonable way of doing it is to set it over. So here's what I'm going to do. I will go ahead and set it for review. I'm going to set it for review on January the 4th, 2023, 1/4/2023, and that's going to be at 9:30 a.m. And what you'll do is you'll come back into the Zoom the same way you did today, and the court will simply review this to see where things are. I know the holidays are coming up, so this is a good test here.
You said January. I'm sorry, you said January. What was the date?
January 4th, 1/4/23, 9:30 a.m. All right, let's get the commencement date on the installment payments. So when is your next payday, sir? Because are they
My
going to get
my next pay date is the 11th.
So yeah, you could probably prevent the garnishment on that next pay date. So let's set this up for the 28th, excuse me, the 25th of
November. Okay, and that's my first payment date. And do I set it up with his office, or how do I go about making that payment?
I'm gonna put the two of you in a breakout room so that you can talk about the logistics in that regard. Okay.
Okay, thank you.
All right, and you got the next day. You'll likely get something in the mail on it regarding that next date as well. But I'll see you at that time, and hopefully everything is going well.
Okay, and also, do I have, how do I get my paperwork to send to my payroll department?
Yeah, we're gonna get that in the mail to you today. I think you have enough time, given the date that you said is going
Okay,
to occur. All right, if you want to, you can chat me. You can put your email in the chat. I'll have my clerk to send it to you via email.
okay.
And Mr. Perry, thank you again for your patience as well, sir. And I've sent you both a notification for breakout room number 2.
And Judge, just to clarify the objection to garnishment, I assume the court's denying his objection to garnishment, releasing all withheld funds to the plaintiff, and then the writ will be suspended under the order
You
for
don't have to
payment.
release. I don't want those funds released. I want that to go towards the payment. You don't have to give that back to me. I want that to go towards my
Have
payment.
already been taken.
Yeah,
No, the
they've
funds
already
that
been taken.
Mr. Cowell, the funds that already been taken by garnishment, those will be released to the plaintiff. Those funds
Okay.
are going to the plaintiff, and then you start the partial payment beginning the 25th. So
Okay.
those funds are going to be turned over, but the garnishment will be suspended so that you can make the voluntary payments. And,
Okay, that works for me.
All right, thank you.
all right, good day, gentlemen.
Good day, Judge.
All right, this is case number 16-121485. This is Michigan First Credit versus Mitchell Williams. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this case on the 30th of January 2017. That judgment was entered for $2,377.54. And this objection to garnishment regarding Bridgewater Interior LLC. Your appearance for the plaintiff in this matter, please.
Your Honor, Michael T. Mamet, P81102 on behalf of plaintiff.
All right, thank you, counsel. Good morning to you. Do I have Mitchell Williams on the Zoom?
Yes, you do, Your Honor. I'm here.
All right, good morning to you, Mr. Williams. I see your objections to the writ of garnishment, and what you indicated as your objection says the wrong amount. So what do you when you say wrong amount, tell me about that, sir.
I know how much the loan was for, but as far as like the interest, I didn't know it was an interest rate on the loan. I thought it was like an interest forgiveness on the loan. And also, since then my status has changed. Like I married with 5 kids and I take care of my household. So I can't afford what they've been, I can't afford what they've been taking out. They already took $2,711 out of that what they received already.
So how long has the garnishment been going on? How long you been paying out the garnishment?
So it was a crazy situation. So I was already getting garnished from Reliable Auto already, and I didn't know they already had this writ out on me. So I just was wrapping up the garnishment with Reliable Auto, just set up a payment plan with them, and then right after I finally got ADP to stop the wages sent it to Reliable Auto, it was like almost 3 to 4 weeks after they already had received the paperwork from the court to stop the garnishment. I had to call them to stop it and resend them the paperwork. And then the writ started for Michigan First. So I couldn't even afford to even pay partial payments on my last garnishment. Hold on, son. Hold on. I'm in court. Hold on, buddy.
Yeah, you couldn't keep up with those other papers because this garnishment then sucked all the money up on it.
I can't even keep up with my bills as well either. I'm delinquent on a lot of my bills. Like I said, I got 5 kids, high school, all the way to the diapers right now. So,
all right. Well, you're replenishing the earth, all right?
Yeah.
So how much money is taken out on each garnishment period? Pay period?
Man, I get paid every week. So, say if it's like, well, my last garnishment was like $140. The one before that was like $200, and then another one before that was like $309. Like they almost taking
so basically
$1,000 to $1,100 a month.
$1,100 a month. That's what I was saying. Okay.
Your Honor.
Go ahead, counsel.
Your Honor, if I'm able to share my screen, I can actually show the court the exact payments that we've received. It's averaging $183.92 right now. And there's just under $1,200 remaining. So what I was going to mention to Mr. Williams in the breakout room is if he lets this thing ride for one more month, it'll be paid off and we'll be done.
Just hold.
Can't do it.
Hold on a second. Wait, were you finished, counsel? Were you finished, counsel?
What was that, Your Honor?
I said, were you finished? I know you got to interrupt. So, okay.
Oh, no, thank you.
But you're saying after, basically after the garnishments that have already taken place, there's something like $1,100 or something left, right?
As of this morning, it's $1,180.37. So what I was going to mention to him is if we did reach some type of agreement, and given everything's got to go through the mail and everything, and he's going to end up getting hit this Friday and most likely next Friday, if we entered into a payment plan today, again, this thing's gonna be paid off in 4 weeks. So by the time the mail gets through and everything else, like I don't know if the timing necessarily benefits Mr. Williams at this point.
I understand what you're saying. Well, Mr. Williams, you're not gonna be able to avoid the garnishment this week for sure. But we could stop it in time for next week. And I guess with the garnishment this week, you're gonna be likely under $1,000 as the balance. So what did you want to pay per month? I mean, you drag it out a little bit, but I understand that is better for you because of your situation with the other creditor as well as with the children and so on and so forth. Go ahead, sir.
Okay, well, one thing I wanted to add, Your Honor. Well, I have ADP has a hold on anything that gets garnished from now on out. So it had a payment, the last payment that went out for last week, I believe, got held. This payment got held. This check got held. And then next week is going to get held. So every payment is going to get held by ADP until the court order from today goes to ADP.
So wait a minute, ADP is the other creditor, correct?
ADP is the payroll provider for Bridgewater.
Oh, okay, I got you. Okay, so you're throwing it in. All right, so here's my point. If I suspend the garnishment, you'll be able to take it to your payroll department. It won't stop it this week, but it'll stop it next week.
Yeah, it is. Stop it, but they won't. I'm saying Michigan First won't receive any money at all. They won't receive anything. That's what I'm saying. Right. So I can afford $50. $50. Say $100 a month. I can afford.
All right. So you're so close, and that's what the issue is. Okay. So I'll go ahead and set it up. I'll go ahead and set it up with a $100 payment, and I'll commence that payment. You're gonna get hit with one more garnishment, so I'll commence that payment on the 2nd of December. So you'll start making voluntary payments of $100 a month starting December the 2nd. I'll suspend the garnishment after this Friday. You should not get garnished after that, not under this case. And then you'll have until December the 2nd to make your payment of $100 and make that payment per month until you finish out this particular case. You understand?
No problem. I do understand that. There's one thing I understand.
Well, no, I just want to make, I'm not saying you're dumb or anything. I just want to make sure you understand what to expect from the orders.
Oh, no, I that's what I'm saying. I understand everything. I expect it. You know what I'm saying? So I've been through this already, like I said before. I expect it, but it's just a setback that I got to go through.
Gotcha. All right. So those are going to be the orders in this matter, Counsel.
Your Honor, very quickly, I don't know if the court already signed the order. Is there any way that I could persuade the defendant to make an offer at $150 a month?
No.
Just given he does get paid weekly and it's $200, basically $200 every
Here's
week.
Here's what I'm going to do. I'm going to put the two of you in a breakout room. Obviously, you know, Mr. Williams.
Yes, sir.
Williams,
yes, sir.
You have a gentleman's discussion with me. Have a gentleman's discussion with this gentleman as well. That's how you do that. The ideal here, the only reason any of this is discussed is to try to end this up as soon as possible because you're so close. If you were like, you know, 5,000 in debt, we wouldn't be having this discussion. So you know, you don't have to agree to anything, but you know, it's a discussion. I think it's worthwhile. I'm prepared to sign the orders, but I'm sending you the appropriate notification so that you can go and have a discussion, and I'll be here when the two of you return. Thank you.
Okay. Right now, I'm going in now. Thank you.
And Madam Counsel, Ms. Baker, which one are you here on?
The Auto Club Group versus Deandra Fields, Cedric Fields, and Deanna Lucas.
I am so sorry. This one was sitting off to the side. Maybe I pushed it to the side. I don't know what happened, and that's why you're out of order. I am so sorry to parties on this. Wow. Here you are being last. I'm so sorry. This is case
That's
number
okay.
21-1768. This is Auto Club Group versus Deandra Fields. And this is deals with Cedric Fields and Deanna Lucas as well. This has been before me a couple of times before. I believe there's a motion for summary disposition, but I have it set up for review. Check it. I have it set up for review. All right, your appearance at this time, Council.
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiff, the Auto Club Group.
All right, thank you, Councilman. Certainly, thank you for your patience. And this one, I don't know how the file got pushed aside. I'm sure I did it, but that's why you're at the end. Your name for the record, ma'am. Good morning to you. Tell me your name, ma'am.
Deandra Fields.
All right, thank you, Ms. Fields. Good to see you. Thank you for your patience as well. I'm sure you heard me talk about how somehow I this file got out of. So, all right. So, Madam Counsel, tell me, update me, see what's going on here to the best of your ability.
This is the date and time set for plaintiff's motion for summary disposition, Your Honor. I do note that the other two defendants do not appear to be on the Zoom call.
They're here.
We're here. Okay.
Yeah, I'm familiar with how they typically appear. It's usually one call, but all three persons on the Zoom. All right. So, did you receive a copy of the motion for summary disposition, Ms. Fields, Ms. Lucas, Mr. Fields?
Yes.
All right. I don't believe that I received a written response to the motion, but I'm going to hear counsel in this regard, and then I'll give you an opportunity to respond to her petition. In just one moment, I'm back on the record regarding the matter with Michigan First versus Mitchell Williams. The suffix in that matter is 1485. All right, thank you, gentlemen, for having a gentleman's discussion. I'm prepared to sign orders. Counsel, anything at this time?
No, Your Honor. I posed the 150 to the defendant. He's not willing to do it. He keeps saying that he can't do more. I asked him if he'd be able to provide, a few of his bank statements or an itemization of his expenses as well as his income, just to determine whether or not it is truly reasonable. And he refused to do so.
It's not that.
I mean, at this point.
Stop, sir.
Oh.
Okay. All right. Well, here is where I think that given the amount of judgment, the amount that is owed on the judgment, the defendant's indication to the court of his family circumstances and financial wherewithal would suggest that the $100 a month is not an unreasonable way to resolve this case, and that's why I've indicated that I would allow that amount. If the judgment was higher, then I would likely be inclined to set the amount a bit higher under all the circumstances. But given that there are several garnishments that have taken place, and given the balance of the judgment that likely exists, the amount that is requested is not unreasonable. If the parties agree to 150, that wouldn't be unreasonable. 100 is not unreasonable either. So I'm going to go ahead and set it there. And I've already given you the dates, and I'm signing the appropriate orders to effectuate this. And again, the funds held under the garnishment will be released to the plaintiff, and the garnishment will be suspended contingent upon the payments. All right. I wish both sides well. Good day to you.
Thank you, Your Honor. Real quick, what was the start date that you had provided?
I didn't hear you. Say it again, sir.
What was the start date that the court provided? I believe it was in December.
December 2nd, 2022.
All right. Thank you very much, Your Honor.
Your
Have a
Honor,
great day.
when I make payments and who I make payments to.
I thought you guys were talking about.
No, no.
It kind of got heated in there, and that's all. We ain't even talk about.
Okay, here, go back and, I'll send you somewhere else. Some people know how to go back, some don't, so let me do it this way.
Thank you, Your Honor.
There
Thank
go.
you, Your Honor.
All right. All right, and we're back on the record regarding Auto Claw versus Fields et al. This is 1768. And Madam Counsel, you may proceed by way of argument on your motion for summary disposition regarding this matter.
Thank you, Your Honor. This is an equitable subrogation claim. My client is trying to recover benefits from an uninsured driver and owner of the vehicle. This was an automobile accident that occurred on September 16th of 2020. There was no police report filed, Your Honor. However, in support of our motion for summary disposition, we did attach a report of loss, Plaintiff's Exhibit 1, which includes a narrative as to the events that occurred. My client did attempt to file a police report also the next day, and that is also that information is also noted in the attachments to our motion for summary disposition. Again, this was an accident at a four-way stop sign. My client proceeded through the stop. My client's insured proceeded through the stop sign as was her turn, and then the defendant proceeded not her turn, and a collision occurred. Again, these details are noted in that report of loss. Due to the negligence of the defendant, Deandra Fields, who was the driver of the vehicle, my client suffered collision damages in the amount of $3,543.20. And the amount of the damages is also supported by documentation attached to our lawsuit. Again, Your Honor, there was no police report filed. We have attached documentation from my client to support the narrative, and there's been no response filed to the motion for summary disposition. In the answers to interrogatories, the defendant admits that she was in a motor vehicle accident, and she admits that there was no insurance on the vehicle. There was no response to the motion for summary disposition filed, and the defendants cannot rely on the pleadings alone in her denials. We're asking for judgment be granted in our favor.
All right. So, Counsel, let me ask you regarding the question of fault in this matter, because while there's not been a written response to the motion for summary disposition, it seems to me that in this matter, that the answer and the plaintiff's, the defendant's arguments all along that there is no independent support, independent document or any statements by way of answer to interrogatory or anything wherein they admit being responsible or being at fault regarding the accident. In the request to admit, the defendant specifically indicate no, the accident was 100% her fault. So, in relationship to the fault issue, because that seems to be a fact question. Go ahead, Counsel.
Again, Your Honor, we've attached documentation showing that the narrative was that the defendant was at fault, and there's been nothing presented by the defendant to show otherwise. The courts have been very clear when we have an uninsured driver that uninsured motorists are to be penalized by personally bearing all economic costs without regard for fault, which may have been avoided if they had complied with the requirements of the No Fault Act and obtained insurance. The defendant was driving an uninsured vehicle, and my client is entitled to recover the benefits that they had to pay to their insured.
All right, thank you, counsel. Ma'am, you may speak at this time, Ms. Fields.
Okay, Your Honor. I don't even know where to start. I did send in pictures. I don't know if you received them. I did email pictures of my car and her car. About how, and it says in this paperwork, it said that my passenger door hit her front end, which I don't see how that is even logically possible for a car door to hit someone else's front end. I didn't have front end damage. I had door damage, a whole gas door. I paid out of pocket over $1,000, and I have a receipt for that. And I sent that into, so I don't understand how I owe anything when I didn't hit anybody. She hit me. And and their proof is in the pictures. I don't know if she got the pictures because I sent them. So I don't know. It's just
Let me answer a couple of your questions. Then I'll let you speak again. Certainly, the fact that someone hit you or hit me or anybody else does not mean that they are at fault. The fact that you hit someone does not mean that you're at fault. If you hit someone who happens to be in the intersection when they're not supposed to be there, then it's not your fault. So if what you're talking about is a four-way stop, then if you come into the intersection at the time you're supposed to, and someone else comes in and you hit their door, it's not your fault. Likewise, if you're in the intersection and someone hits you at the side, if you are not supposed to be in the intersection, then that's still your fault, even though you got hit. So fault is not determined by whether the door was hit or whether it was front end damage or back end damage or so on and so forth. Except in some cases, I mean, typically, if a person is rear-ended, then obviously the notion is that a person is supposed to drive behind you at such reasonable rate of speed that they should be able to stop. And oftentimes, even if a person suddenly stops, the rear-ending person is going to be at fault, except in some narrow circumstances. But these sideways collisions, oftentimes, it depends on what the traffic signal device is. But I wanted you to understand it because you made it sound like the fact that you were hit on the side means that it couldn't have been your fault. That's not true. That it couldn't have been your fault, because I think that you raised another reason. I think you said something previously when you were here with me before that other person, you're saying the other person ran over the light of the stop sign. That's what you said.
Yeah, I can tell you exactly how that whole thing played out.
I didn't ask you that. I asked you a specific question, right? You heard my question, right? All right. Is that what you're saying, that other person was in the intersection when they're not supposed to be there? That's what you're saying? Okay. All right. What else you want to tell me, man? Anything else you want to tell me? Go ahead now.
That's how it played. Like, everybody knows how four-way stop works. Whoever got there first goes first. There's an order. The other person who sat there and hit me.
Let me stop you for a moment. Because what you're trying to make, what you're trying to do is you're trying to draw a conclusion that fits in every situation. You're saying that because you got hit on the side in the intersection, that by definition means that you were rightfully in the intersection. That's not necessarily true. That's not necessarily true. If it's a four-way stop or whatever type of stop sign situation, the fact that another car hit you while you're in the intersection does not mean that you are lawfully in the intersection. That's the point that I'm raising. And you're making it, you're saying, almost rolling eyes a little bit, like it's common sense that if somebody hit you at the side, that means that was their fault. Factually, that's not necessarily true. I think what you told me previously is that the other person ran the stop sign. I think that's what you told me previously, or ran the light or whatever. it
Yeah,
was.
if it was my turn to go and she went, that's what she ran the stop sign.
Yeah, but if it
That's
was-
how that goes.
That's a, yeah, well, I don't think you understand what I'm saying, but I understand that. Anybody else want to talk?
Yeah, can I say something, Your Honor?
Yeah, go ahead.
Well, I'm trying to figure it out too. Say that again, Your Honor? Oh, Cedric Fields, Your Honor, Cedric Fields.
Thank you, Mr. Fields. Go ahead.
And I'm just trying to figure out too, you know what I'm saying, if she going through an intersection and then she get hit, like, how could it not be somebody else's fault? Only fault she had that day, she didn't have insurance that morning. But the car always have insurance. It got insurance right now, we don't even drive it. And it's fully covered. And I'm just trying to figure it out too, because like on the report, it says her door hit the front end of a car. That don't even sound right. It sounds like a 7-year-old said something like that. A car door hit somebody's front end. So that's all I got to say, Your Honor. I mean,
Yeah, that's certainly not artfully put, but I want to posture something to you, because this case is going to be decided on something kind of like other than this. But I wanted to be clear, I wanted to be clear to both of you that the fact that you're in the intersection and somebody hits you in the intersection does not mean that you are lawfully in the intersection. If you proceed into the intersection without stopping at the light or stopping at the sign or moving without giving due right to the person that has the right of way, then you move into the intersection at the time that they're moving into the intersection and they hit you. Somebody shouldn't be there. It doesn't necessarily mean the car that hit you shouldn't be there. It could be the car that got hit shouldn't be there.
well, that's what it sounds like they trying to. Well, I hear what you're saying.
No, let's forget the statement that a side door hit a car and all that. That don't mean nothing. But here's what
that's
I'm
what
saying.
they said.
Okay, well, you're not listening, so okay.
I'm listening I'm listening to everything you're saying, Your Honor.
No, you're not listening because of the way that you responded. It's clear to me that you're not listening. And if the two of you want to continue, if you want to continue to believe that if your car gets hit, it means that the other person is at fault, then you probably not learning lessons from this, but maybe that's not a part of this. Anybody else? I know there's a third person that want to say something on this.
You want to say anything?
Hi, Your Honor. This is Dina Lucas. Hi. Well, I'm trying to figure this out is what she was telling me was, okay, they're at the four-way stop. There was other people in front of all the other cars that were all there. And so when that person went in front of her, that was their turn. She was there. Everybody else had their turn. And then she proceeded after the stoppage. She went through and then the other vehicle went through and the driver was not paying attention.
Let me stop you. I hope the two people around you are hearing what you just said, because that's incredibly different from what either one of them said. That's all I'm saying. If what you're saying is correct, that's the way in which a person could be in an intersection, get hit by somebody else, and it's that other person's fault because of what you just said. But if all four of us arrive at the intersection and I pull out and then another person pulls out, it doesn't matter which car hits which car. The person that shouldn't be in that intersection is the one who's at fault. What you just said establishes that. What you're saying is that she told you that all the cars were at the intersection, that whoever was to come through came through, and then it was her turn and she came into the intersection. That's not what she told me, but that's what she explained to you. Because just being in the
That's written down in documentation. I had to write a statement. That's written in the statement.
I don't care.
Okay, well then.
I asked you what happened.
All right.
I asked you what happened.
Not paying attention. She was eating.
I don't care what's written down, and you have to explain to me what happened in this case. All right. Anybody else?
Well, can I say one more thing, Your Honor?
Yeah.
Is there any way we can get like a court appointed lawyer or anything? We're not lawyers or nothing like that, so we don't know what's really going on. No.
Not in civil cases. You don't not in civil cases. You don't get an appointed lawyer in a civil case. Those are criminal cases. Here's the problem in this case. The problem in this case is the way that the law works on this. When there is a situation where there is a question about who is at fault, and oftentimes when there is not a question about who is at fault, the insurance issue becomes the critical issue. And what happens is the law penalizes a person who is operating an uninsured motor vehicle. Even if you have insurance, if the vehicle that you're operating is uninsured at the time that you're operating that motor vehicle, then what the law does is it assesses fault to you for the damages caused to a third party in relationship to the accident. That's really what the challenge is in this case. Now, there are some situations where that challenge can be overcome, where there is overwhelming evidence that someone did something that was so outside of the realm of what is reasonable that even the person operating an uninsured motor vehicle should not be held liable for the expenses that occurred as a result of that. For example, there is someone who is a drunk driver, and that drunk driver drives and hits you and tears your car up and so on and so forth. Well, it turns out you're operating an uninsured motor vehicle. You're not responsible for the drunk driver who got drunk and ran into your car and hit your car and so on and so forth. But in circumstances like are presented here today, the fault falls on the person who is operating the uninsured motor vehicle. Even though arguably they may be able to say that it was somebody else's fault, the law then says they had no business being operating that vehicle because that vehicle was not insured at the time that the vehicle was being operated. That's the problem with this case. And that's why I asked opposing counsel regarding the issue of fault, because maybe it goes back and forth about, well, maybe they should have been in the intersection, or maybe this other person should have been in the intersection. But at the end of the day, if you read the no fault law, it penalizes persons that are operating an uninsured motor vehicle. And there's no evidence that this vehicle was insured on the day that the accident occurred. No evidence that it was insured. If you got something proving that the vehicle is insured, then we go to the next issue of fault. We can go deeper into that, but you can't establish that the vehicle was an insured vehicle on the day that it was being operated. Then you end up, it ends up being your fault because of the vehicle not even supposed to be there on that date because it's not insured. Counsel, anything else on your side of this?
I have nothing further, Your Honor.
Anything else, Ms. Fields on this, Madam.
I get that you said like about the scenario with like a drunk driver. Okay, well, she was a distracted driver because she was for sure eating in the car when she hit me. So isn't that kind of like the same scenario, a distracted driver? No? Okay. Well, if I feel like I should not have to pay nothing, I still stand on that. I should not have to pay anything. I paid out of pocket. She paid her stuff. She said in the documents it said her car was totaled. It wasn't. She drove away. So yeah, I don't feel like I should pay for nothing. So I mean, we can keep going tit for tat. I'm not gonna pay.
No, the court doesn't do tit for tat. The court operates by virtue of what the law is. I agree with you that you shouldn't have to pay anything. It should be the insurance coverage on the vehicle that would be paying for this. That's the only way that goes. And there's no insurance. That vehicle is not covered under the policy of insurance. Therein lies the problem. And that's probably not even a situation that's germane to you, because I don't think that you are the owner of the vehicle. But operating an uninsured motor vehicle is problematic in that way. I mean, it's that we went through some of the issues about fault and what have. I don't expect people to agree with me, and notwithstanding the fact that 40 years of being in the law and 30 years as a judge, I don't expect people to agree because everybody knows the law. You just know the law automatically. I'm being facetious, but that's the way that people see it. But what I do try to do sometimes is explain to people and help them understand how this stuff applies. I can't make up the law. I can't change it. I apply the law. That's what I do. And if you don't get that, then what happens is that you don't know how to deal with things going forward. If you operate an uninsured motor vehicle, that's automatically a problem. And unfortunately, there are people, not necessarily in this case, the defendants in this case, but there are people that operate uninsured motor vehicles for economic reasons, et cetera, et cetera. They run into problems. Sometimes policy get canceled and they just get ready to make the payment and so on and so forth. But if you operate an uninsured motor vehicle in the state of Michigan and you have an accident, except under some of the most extraordinary circumstances, you're going to end up being responsible for the damage that occurred in that accident because the vehicle you were operating was an uninsured motor vehicle. That's the problem in this case. And in this case, there is a dispute about who's at fault in that intersection. I'm not sure. I'm not saying that it's this person or that person. I had a discussion with Ms. Fields simply to point out that the fact that a vehicle got hit by another vehicle doesn't mean that the vehicle that got hit is not at fault. There are people all the time that are in the intersection that should be there and get hit. But that's not really the issue in this case. Ultimately, the issue in this case is that there is a dispute regarding who's at fault. But then the statute resolves that when there is the operation of an uninsured motor vehicle. And the operation of an uninsured motor vehicle it resolves this case. It puts the fault on the owner operator of the uninsured motor vehicle. And because that is the scenario here, the plaintiff is entitled to a grant of their petition for summary disposition on that particular issue. The court made its inquiry because I wanted to see if there was enough to establish whether there was fault and that issue. But I don't even need the issue of who's at fault because the statute makes the person operating the motor vehicle, the uninsured motor vehicle, the person who's at fault under these circumstances. For that reason, I will grant the petition for summary disposition. I'll enter judgment on the motion for summary disposition in this matter. Now, counsel, tell me, why should the judgment be entered as to Deanna Fields, Cedric Fields, and Deanna Lucas?
Ownership liability, Your Honor. Cedric Fields and Deanna Lucas were the owners of the uninsured vehicle.
All right.
Ownership liability statute is 2.257.401.
All right. And of course, the court is aware of the statute. I just wanted to hear on the record what the ownership was in regard to this vehicle. Given that those persons were the owner and operators of the motor vehicle, the court will enter the judgment by summary disposition at this time. The term is great. All right, that is my order. And I do wish all sides well in this matter. Good day to each one.
Thank you.
Your Honor, so is there like another court date or something, or that's it?
No. You know, this there is a judgment that's entered. You can always appeal this to the Wayne County Circuit Court to try and get my order overturned. Again, the issue turns on that the operation of the uninsured motor vehicle. That's a challenge in this case, and that's a challenge in every case like this. It comes up. If that challenge was not there, this would be one of those cases where it's hard to determine who's at fault. And if it's hard to determine who's at fault, then the person being sued, the case is dismissed because you can't really determine who's at fault. This is not one that one can look at and say, it was clearly that person's fault, or it was that person's fault. Can't determine. And if they can't determine, the person that's suing you have to prove the accident. So if they couldn't prove it, if they couldn't prove that it was your fault, then the case would have been dismissed. The problem in this case is that when you have an uninsured operation of an uninsured motor vehicle, then the statute assesses fault. It penalizes the person operating the uninsured motor vehicle. That's what happens in these cases. And let me go off the record because you know, I don't like this statute, but it is a statute. It is the statute that exists, and you can only imagine. I won't talk about it much, but you can only imagine what people influenced the legislature to pass such a statute, and what their interests may have been. Connected to that is what's called the Civil Liability Act. That's another statute. That means that if you are operating my motor vehicle, that if you decide to do something crazy or whatever, I'm responsible for anything that you do. And you could imagine the people that they came up with some of those kind of rules. But yet, nonetheless, they're the rules that we live with in the state of Michigan. Now, for sure, if you get hit by someone operating an uninsured motor vehicle, let's say you get ran over by a car, somebody hit you, they did something negligent, you're gonna be highly perturbed that they're operating that vehicle and that vehicle is uninsured. So sure, there was some thought and some notion that, you know, these people that operate these vehicles that are not insured, they could cause a lot of economic harm and physical harm to people, and they have no responsibility because they don't have any insurance. But to go as far as to, for the statute to go as far as to say that it becomes your fault if you're operating an uninsured motor vehicle, that's a lot. And like I said, I'm not crazy about that particular statute, but that is what the statute is. And that statute became consequential. It became consequential in this case because, but for that, you know, some other cases, it doesn't even get to this. In other cases, you have a police that comes out to the scene. They draw up a sketch and they assess on their report exactly whose fault it is. That's not what happened in this case. Not what happened in this case. It's not clear as to whose fault it is. And if it's not clear as to whose fault it is, then that goes to the person that is being sued. So if I sue you and it becomes, I'm not sure whether it's his fault or her fault, then that means that you win. You don't win necessarily because it wasn't your fault. You win because I can't prove that it was your fault. In this case, I don't believe that they would have been able to prove by a preponderance of the evidence that it was your fault. The proof would have been left open. I don't think they did prove that. But with the statute saying that if the vehicle is being operated as uninsured, then it automatically becomes your fault, except under extraordinary circumstances. The circumstances have to truly be extraordinary for that to occur. Classic example is people running from the police, and they run into you and tear up your car, and so on and so forth, and cause you injury. Then and you're operating an uninsured motor vehicle. Well, under those circumstances, there is no assessment of fault towards you and liability towards you, even though you operate an uninsured motor vehicle, because of other criminal superseding act that's being done in relationship to you. So that's as much as I can give by way of explanation as to how the law applies. And I wasn't trying to give you a hard time on the other thing. The other thing, I was simply putting out a proposition that, and it happens all the time. And when you think about it outside of your case, you'll see it. And what happens is that a person can be in the intersection and get hit by another car. That doesn't mean that the car that hit them is at fault. It may be that person that's in the intersection is not supposed to be in the intersection at that time. That's the simple point I was making. I'm not saying that's what occurred in this case. I'm saying that you can't say that because one car hit another car, that is the fault of the person that hit the other car. You can't say that automatically. It depends on the circumstance. And in this situation, the circumstances doesn't tell me whether it was your fault or the other person's fault. And like I said, if that was all this case is about, that means that the person suing you is not able to prove that it was your fault. You don't have to prove that it's not your fault. You don't have to prove that. The person suing you have to prove that it's your fault. So what you said, if it wasn't for this non-insurance stuff, what you said would be enough to raise a question. It wouldn't be that I said, well, it's not her fault, or well, it's your fault. Where I would have been left in this case is that I don't know whose fault it is. And if I don't know whose fault it is, you win. You see how that works? And this is a case where it's not clear whose fault it is. And of course, the no fault statute or the no insurance statute tells me that I got to find that it's the person's fault in the accident who didn't have insurance on the vehicle. And that's one of the, I think it's one of the worst laws. There's other ways to penalize that. A person operating an uninsured vehicle, you get a ticket, you can hold them accountable for that, so on and so forth. But to make them responsible for the damages that occur, where it may not be their fault, I think that's a bit much. But that's what the law does. Okay. So I didn't mean to hold you up all that time, Ms. Fields. But you can appeal it to the circuit court. the gentleman that was with me was talking about an appointed lawyer, that we don't have any way of doing that. But in this case, even if you had a lawyer in this case, that does not change that particular rule. And that's what the problem is. Any lawyer in your case would have been able to throw a question as to whether, as to whose fault. It's just not enough evidence in this case to establish whose fault the accident was. They're not enough. It's on both sides. Say it was their fault, I can't say it was yours. So if I can't say it's your fault, then they can't win if it's not your fault. They have to prove it. You don't have to prove it was your fault. They have to prove that it was your fault. I've been with the statute, you heard me repeat that before, the statute did something different. All right, any questions before I go on and do some of this work that I got time?
No, that's about it.
All right. I would have loved to see something of a different outcome with this. I'm looking at something over here. But that's unfortunately the way that the law applies in those kind of circumstances.
Okay.
So I wish you well, ma'am.
All right. Thank you, Your Honor.
All right, thank you. Good day to you.
You too.
Deborah?
Yep. So